Okay, good afternoon, everybody. Um, we're glad that you've joined us this afternoon for this exciting webinar, exciting session. I'm really excited about this because I know I'm going to benefit and also many of the young members here. Um, Today, we bring to you the first activity from the Young Members Committee of the Chartered Institute of Arbitrators Uganda chapter. I extend apologies from our chair, Gava Mukulia Charles. He's not able to join us, but he sends his regards and he's appreciating all the members, all the young members that have signed in, that have logged in for this activity. And kindly look forward or look out for our activities that are coming up for this calendar year. And please join us. And let's become better ADR practitioners. So without further ado, it is my pleasure to welcome you to the first webinar for the Young Members Committee. This discussion is going to be about my first appointment as an ADR practitioner, as an arbitrator, as a mediator, as an adjudicator. I'm personally really excited about this one. Joining us this afternoon, we have um, one of our own. We have Albert Mukasa. Albert Mukasa is an advocate of the courts of judicature in Uganda. He holds a Bachelor of Laws degree with honors from Makerere University School of Law and a diploma in legal practice from the Law Development Center. Albert has a postgraduate diploma in international construction contracts from the University of Paris. University of Paris, Pathson, I think. You pardon me. He's currently also pursuing a master's in construction law and dispute resolution at the King's College of London as a Chevening scholar. Albert is also a managing partner at M&K Advocates and heads the disputes team, where he has been involved in several high-stakes disputes before domestic and international arbitral tribunals. He also lectures ADR corporate and commercial practice at the Law Development Center. He is a fellow of the Chartered Institute of Arbitrators and an empaneled arbitrator. He has acted as a sole, wing, and presiding arbitrator in several commercial disputes in Uganda and abroad. He is also a former ICC young ICC representative for Africa, and is in this role he organized several events to promote international arbitration across Africa. I must say I've attended a number of these. In 2024, Albert was recognized by Africa Construction Law with an award for his contribution to construction law in East Africa. He has also authored several articles on international arbitration and construction law. He has published that have been published in leading journals such as Construction Law International and the ICC Dispute Resolution Bulletin. Ladies and gentlemen, welcome Albert Mukasa, one of our panelists this afternoon. Alongside Isaac, we have Engineer Cyrus Titus Oumu. Engineer Cyrus is a construction professional with over 21 years of experience supervising building projects, overseeing the development of water supply and sewage infrastructure, and managing water and sewage utility operations. He has delivered numerous high-profile public and private sector projects, demonstrating his extensive qualifications and experience. Cyrus holds a Master of Science in Construction Law and Dispute Resolution from Leeds Bucket University, a Master's in Business Administration from Heriot-Watt University, and a Civil Engineering degree from Makerere University. He has professional credentials, including being a FIDIC certified adjudicator, a fellow of the Chartered Institute of Arbitrators, and a licensed dispute board practitioner with the dispute resolution DRBF, which collectively showcases his recognized experts in dispute resolution and engineering. Engineer Cyrus is also currently serving as the Chief Executive of CAT and ASH Limited, providing specialized services in dispute resolution, contracts, and claims advisory within the infrastructure sector, both locally and internationally. His leadership and expertise position him as a key resource for complex infrastructure projects. Ladies and gentlemen, welcome Engineer Cyrus for this webinar this afternoon. And last but not least is a young lady, Wambui Mungai from Kenya. Thank you for joining us, Wambui. Wambui is an advocate of the High Court of Kenya and has over 7 years post-admission experience. She is a fellow of the Chartered Institute of Arbitrators and a certified mediator and certified arbitral tribunal secretariat. Wambui is a principal associate in the dispute resolution practice group at the firm of Muhammad Mungai LLP, specializing in constitutional petitions, environmental disputes, commercial, civil, and criminal litigation, tax, and alternative dispute resolution. As a testament to this, Wambui was recently awarded as one of the among the top 100 litigation lawyers in Uganda 2025. Wambui has served as a sole arbitrator on numerous arbitral tribunals and has extensive experience representing clients in international, regional, and domestic arbitrations as a counsel, including her most recent success in LCIA case, under LCIA case, KU Railways Holdings Limited and RVR Investments Limited versus Republic of Kenya and Republic of Uganda, against a case that was amounting to a tune of $2 billion US. Ladies and gentlemen, welcome Wambui. This afternoon, our panelists are going to give us insights. They're going to share with us how to identify opportunities, prepare for our practice in ADR, identify a good dispute to take on, and also how to proceed in terms of executing or resolving the dispute for the disputants. With that, allow me to say that every journey begins with a journey of 1,000 miles begins with a single step. And I believe that the single step that we as ADR practitioners should be taking, where theory meets practice and where a practitioner truly begins to shape their professional identity, is at your first appointment as an arbitrator. I believe we have all, some of us or all of us here have gone ahead to enroll for the trainings, enroll for certifications, and avail ourselves to opportunities. But what happens when you get that first opportunity? Without further ado, allow me to dive into the discussion with our panelists. I'll start with Albert. Albert, kindly give us or guide us, for those of us who are always envisioning a career in ADR. How do we move from aspiration to competence and ultimately secure our first appointment?
Thank you, Amina, for the question and the introduction. I'm happy to be here. Previously, a young member myself, but most importantly, part of the CIAB, both on the education committee and one who is in charge of helping the young members move forward in terms of their vision. Now, when it comes to because whereas the discussion will be about the young members, but when you're taking your first steps as to whether to pursue a career in ADR, it doesn't matter whether you would be qualified as young in age, but you could also be qualified as young at heart or in spirit. So in other words, you are taking your first steps. And in most cases, or previously, what we had was ADR was left to people who are looking forward to their retirement. It was a retirement plan that, if I practice for over 40 years as a lawyer or an engineer, when I no longer have the physical strength to be on site or to be in the courtroom, then I will embark on a journey in ADR. But that is no longer the truth because ADR has become part of the fabric of dispute resolution. So, and in some cases, whereas the word used is alternative, some people argue that it's actually appropriate dispute resolution. So it is important that when one is making their plans and saying, okay, I might want to pivot to ADR, then the question is, how do you start? So for me, I would put it into three simple words: strategy, preparation, and execution. At the level of strategy, that's where you're dealing with ideation. You're coming up with the idea that, I think when I look at my professional life, I might want to find myself as an ADR practitioner. And having said that, the next step would be, which path or pathway are you taking? Because with ADR, it is quite extensive. As you have heard, all of us have, you find Engineer Cyrus is an adjudicator, is an arbitrator. Wambui is both an arbitrator and a mediator. Myself, I juggle all the three. So you find that all these pathways are available in ADR, but there are others like other expert determination and the like. So having realized that, this is what you want, you have already picked the pathway, then the next step would be, what is my plan for the next 5, 10, 15 years from now in terms of ADR? Then you'll be able to scale down in terms of where do you want to be. For myself, I think the journey started much earlier than practice. I think the first step was in law school, where I was at the time, I will not say the year because it will place me in terms of the age group, but the internet was a scarce commodity and we had to go to internet cafes, and those no longer exist nowadays. And when I would have time, I would go there. And one of the things I was looking at was, what is arbitration? Because we did not have it as a course at the university at the time. It was just a footnote in terms of in civil procedure. So I was Googling about arbitration and all that. And then I landed on the Young International Arbitrators Group of the LCIA. And that was the first time I'd seen an initiative that was encompassing what I was looking for. So as a young member, I signed up. And having signed up from there, I started receiving notifications, learning about this whole process of arbitration. So from there, when I started practice, it was much clearer for me that this is where I wanted to be. And I would pay regular visits to the Center for Arbitration and Dispute Resolution in the hope of understanding or getting someone to hold my hand and be able to build on this dream that I had for ADR. So it started with an idea, then went to the second step. How do I fulfill the idea? So by joining the Young International Arbitrators Group gave me an indication of what was the gap in terms of Uganda. What was there any initiative that would be done for practitioners or young practitioners in Uganda? So from there, I joined other groups, and when in my, I think, second year of practice, I started moting, doing some courses. But by then, we did not have anything in Uganda that would train. I think at the time, you would either go to come to London or Nigeria or Kenya. So finally, I made my choice. I said, let me go to Kenya, and that's where I started my journey. So when it comes to the pathway, like I said, strategy, you developing the professional development plan, then taking steps in executing by preparing yourself and saying, okay, this is what I want to do, and this is how long I'm going to take in doing it. So by planning, I was able to identify courses, identify um, um, activities. For instance, in 2014, that group I was talking about came to Uganda, and having been part of the young members then, I was able to go and attend the event that was hosted at Serena, I think, at the time. And the young members then, one of them has just been made a KC recently, and I stayed in touch with them, and up to now we're still in touch. So the whole idea of a young member, the definition I gave, both young at heart and young in age, when you are taking those steps, it is important to have a plan, a professional development plan. It's not this webinar that we have today is just the spark to what you want to do. So you must be able to take steps from here onwards. And you take steps by developing a plan. Once you have a plan, it can be a short term, it can be a long term plan, but within that plan, have the different aspects that will formulate your goal of becoming an ADR practitioner. As you go along, for instance, CIAB, why is or the Chartered Institute is very critical and dear at heart, is that it gave me, when I attended my now professional training in Nairobi, it first introduced to me all these pathways in a single course, so that I would understand, I would have this indication of, oh, I'm interested in arbitration or mediation or adjudication for the love of it. But if all of them are you have an idea of what they are, then it is much, much easier for you to be able to make a choice much later on. Because once you do the introductory course, the next step would be doing a pathway course. So that's where you split from the general course to whether mediation, arbitration, or adjudication. So that was very, very vital, because the people I started with, I have some who went on to become mediators, others became adjudicators, and I chose the arbitration pathway. So I think I would say that would be what takes from idea to execution, what one would do in terms of moving forward. So thank you, Amina.
All right. Thank you very much, Albert, for that, elaborate introduction. You've hinted on quite a number of things. You've hinted on selecting a path. You've talked about continuous professional development, networking. So all this is all in line with preparation, preparing yourself, preparing ourselves for our first appointment. And while professional accreditation equips practitioners with theoretical knowledge, the transition from training to handling a first appointment often presents challenges. Um, I request Engineer Titus, pardon me. Um, let us say one of our listeners gets their first appointment. As a first-time ADR practitioner, what key factors should guide his or her decision before taking any dispute? And based on your experience as an adjudicator, what essential terms or procedural matters should be clarified before formally accepting an appointment? Over to you, Engineer Silas, sorry. Engineer Cyrus? Engineer Cyrus?
I think it is off.
Okay. As we wait for him to get back, allow me request Wambui. Is this something you can take on? Can you take this on with for our listeners? Or he's back, I think.
Yeah, sorry, I'm having challenges with my connection. Is it my turn to speak?
Yes, it is. We thought you had left us and gone for Easter. Huh?
No, I hadn't. I don't want to go for Easter too soon. What is the question?
So, picking from where Albert left us, about choosing a pathway, professional development, and networking. Let us say with the listeners or even myself, I've got my first appointment. As a first-time ADR practitioner, what key factors should guide his or her decision before taking on any dispute? And based on your experience, in line with arbitration and adjudication, what essential terms or procedural matters should be clarified before formally accepting an appointment? Over
Okay,
to you.
thank you. Thank you, Amina. I hope my internet is friendly. I will give you a small story. Over 2 years ago, a stranger from Harare in Zimbabwe approached me with an opportunity to act as an employer's representative on a FIDIC 2017 Silver Book contract. Now, the role of an employer's representative is full-time, and at the moment, I do not take full-time assignments. Was that I found a company to take on the role of the employer's rep, and I took a decision to support the company as a contract specialist. So what I did is I signed a professional services agreement with that company, and with the company that the stranger and I agreed on, and have been working on that project as a contract specialist. Now, on the other side of town, I'm domiciled in Uganda. On the other side of town, that same company that was employer's representative partnered with 2 other companies to form a consortium and serve as a construction supervision consultant on a government project. Now, on that project, the parties agreed that I would serve as a sole dispute board member. Now, what happened is, after confirming that the parties, who the actual parties were in the consortium, I realized that the company that I was working with, supporting as a contract specialist on a different project, was part of the supervision team on this project where I was being considered for the DB role. So I called a party meeting with the parties to discuss several matters, including my involvement with one of the consortium members in the construction supervision team. So I recall very clearly when I mentioned it, the room went silent, but the employer thanked me for disclosing the matter and asked the contractor whether they had no objection to me continuing to serve as a DB member. The contractor had no objection. Now, when you are on a dispute board, one of your first assignments as a dispute board member is to earn the party's trust. This was the beginning of the assignment. Had I not disclosed and either party found out at any point during my tenure, I would have failed the impartiality test. Now, of course, we are trained to disclose. When you disclose, there is a risk that you will lose the assignment. But it is worse if your reputation is damaged if you don't disclose your status with and connection with the parties. I want to give a second example. This one, I was invited to quote for a dispute board role. And as part of the documentation I was required to submit, I was asked to provide a disclosure statement. Now, the employer is a government entity and the contractor is a large conglomerate. So I had indirectly done some work for the contractor, but was a broker who had engaged me during the tender process on a separate project to prepare a technical proposal for that contractor. I did so, and the contractor secured that contract to build some infrastructure in the eastern part of Uganda. Now, in my submission to the parties, when they asked me to quote for this role, I disclosed my remote relationship with the contractor. I'm saying remote because the contractor did not directly approach me to prepare that proposal. It was a broker who approached me to prepare that proposal. So to date, I am unsure how the parties handled it, but I was eventually contracted as a sole DB member for that project. So what is the takeaway here? It's important to always disclose, even if it means you may lose the opportunity. And if you are in doubt, always disclose in any case. So you take on the assignment with clean hands. But even if you take on the assignment, you also have to satisfy yourself that you will be impartial as you execute the assignment. Sometimes the parties may agree that you continue, but you can decline the opportunity and pass it on to somebody else. Now, for me, impartiality is very important when it comes to dispute board appointments, but also when you're handling cases. Because when you're handling cases, it is okay to hear both sides because that's what natural justice commands, but you also have to give the other side an opportunity to respond to what the other party has raised. So for me, that is what I spend most of my time currently on adjudications, ad hoc adjudications, but also on dispute boards. I have not yet done an arbitration so far, but that's the experience I have so far with impartiality on case management and at appointments. Thank you.
All right. Thank you very much, Engineer Cyrus. You've opened up the discussion to quite a number of elements when it comes to handling proceedings in ADR. And I must say, the aspect of disclosure is quite important, especially in the onset before taking on any appointment. Otherwise, as an ADR, you risk compromising the process, or you risk losing trust from the parties. So with that, over to you, Wambui. With that introduction to so many aspects, kindly take us through how important is procedure planning and what documents or frameworks should guide a practitioner before the first procedure meeting. Let's just say we've gone through the disclosure aspects and we are finally accepted. So now we are starting a proceeding. Kindly take us through how important procedure planning is. Thank you.
Thanks, Amina, for that. Hi, everyone. It's a pleasure to be here, and thank you for your time this afternoon. I think procedure is the most important thing in arbitration proceedings. The way you structure your proceedings determines the efficiency of how the matter is going to flow. It determines the trust that the parties have with you. It determines the record that will eventually be before the court as and when your award is going to be either affirmed or set aside. And therefore, procedure and the way you structure your proceedings is the most crucial element that any arbitrator should undertake. Now, the first thing that I do when I get an appointment is first read through each and every one of the documents annexed. And the reason for that is obviously to get an idea of what the dispute is about, but more crucially, to give you an inclination as to the elements that you can expect down the line as the arbitration unfolds. Significantly, the arbitration agreement will give you better particulars as to the arbitration rules that are applicable to the agreement and to the proceedings that are to come. Usually the drafting styles may vary depending on when the parties got into the agreement, but ideally they should say what institutional rules apply to the proceedings. For example, here in Kenya, it's usually either the Chartered Institute of Arbitrators or the NCIA. Also, there are generalized clauses that speak to perhaps the prevailing rules at that time, noting that these rules are updated from time to time. So that should always be your starting point. Your act, your arbitration act, depending on whatever jurisdiction you're in, and then the applicable arbitration rules. Now, with those two in mind, what I usually do is I have a standardized agenda, and that agenda has a very wide scope. It encompasses and encapsulates things from the parties to the agreement, to the substantive law applicable, to the language applicable, to perhaps preliminary issues that the parties may have, jurisdictional objections, like engineer has said, conflict disclosures, and it goes all the way up until the sort of hearing that the parties would like to have. Would they like expert evidence? Would they like witnesses of fact? Would they like documentary-only proceedings? Would they like oral hearings? Would they like a hybrid? Would they like to reserve their right of appeal? And so my agenda usually spans around 50 items that are cross-referenced to the Arbitration Act or the prevailing arbitration rules. And what that does is it gives the parties an outline and a guidance, because once I'm issuing my initial letter inviting them to the preliminary meeting, I share the agenda with them in advance for them to look through it, for them to consult their clients, for them to also do research if they are unaware of some of the elements. And so by the time they're coming to the preliminary meeting, they are clear as to their position on each and every one of the cited agenda items. Now, what that does for both of us, as the arbitrator and as the parties, it gives us a structure. You never want to be in a situation where you have commenced proceedings and you've forgotten an item, or perhaps an item has been reserved for further down the line, and perhaps you've not come back to that item. So the most important thing is having an outline, having an agenda that guides you through the procedure that you will follow. And also it gives you a level of professionalism that the parties are coming to you and you know what exactly it is that you're doing. You know the elements that you need to tick off, you know, perhaps all of the aspects that are probable likely to come up. It also helps with your organization because it also helps you to sequence the proceedings moving forward. So perhaps if you have a preliminary meeting and in this arbitration, the parties do not have preliminary issues, then perhaps you know from there on just to dive into the exchange of substantive pleadings. But if you have an agenda item that has preliminary issues, then you know how to structure those at the outset before getting into some of the substantive matters. The third thing that I usually do, and it's crucial, is to have a terms of reference. The terms of reference is a document, essentially a contract between the tribunal and the parties that confirms the relationship, that they confirm that they are aware of the proceedings, because there are sometimes parties will not participate, say they've not been served, say that they are not aware. There are other times that they can appoint a counsel to appear and then halfway down the proceedings say that the counsel did not have proper instructions. So the terms of reference is essentially the contract between the parties, the tribunal, and their counsels to confirm, yes, indeed, they know that the proceedings are ongoing. They know the commitments that they have made to the tribunal, including payments. I know that's usually a touchy subject, but it's the easiest way to address payment is through the contract, because again, like any other relationship, it has to be written down and agreed to, executed and signed, such that if down the line there is ever an issue as to your payments or the sequential nature of your fee notes, you always have something to come back to and to anchor it on. So just to tie in those three elements, is procedure is the most significant thing that an arbitrator can do. And procedure will always stem from the Arbitration Act and the applicable arbitration rules. And once you have assessed those, to reduce them into an agenda that will guide exactly how the arbitration is going to, or rather how exactly the preliminary meeting is going to unfold. But then from that meeting, it guides the arbitrator on how the entire proceeding is going to develop from there, because now you have as much information from the parties as you require and as you need to make informed decisions moving forward. And then the last element would be the terms of reference to secure your position and your relationship with the parties and your relationship with counsel. So procedure is increasingly important. I hope I've answered your question. But again, if you have anything else, drop it in the comment section and I can expound a bit more on that. Thank you.
Thank you very much. Thank you very much, Wambui, for that. It was very elaborate, and you've opened up our discussion further to, so many other procedure matters. But before you go on, Albert, quickly, can you give us just in a line or two, explain or elaborate to our listeners what is a preliminary meeting, what is a mention? Because most of the things you've shared, Wambui, are items that happen in a mention, during the mention, and then also preliminary meeting. Albert, quickly just throw some highlight on that, and then we can proceed.
All right. Thank you, Amina. Now, when it comes to arbitration, as Wambui has highlighted, you have the parties' arbitral agreement. They've gone ahead, done an appointment. It could be one that is administered by an institution. They could have approached the Chartered Institute. It could have been any of the other arbitral institutions. So once the arbitrator has been vested with jurisdiction or has been appointed either ad hoc by the parties or by the institution, then the first step they take is to invite the parties for a meeting. Now, when you compare this to the conventional litigation, it's akin to what would be the preliminary hearing that would be in a civil suit, where you're meeting the judge for the first time. So you want to set the ball rolling. So this preliminary meeting is supposed to guide the entire process from beginning to end. And like Wambui pointed out, you must have an agenda. That agenda spells out issues, both the sticky ones, which the most prominent being the fees. If the institution that is appointed, that has appointed you, does not have a set guideline for fees, then you need to deal with that with the parties. Secondly, issues concerning the procedure timetable. How long would the matter be handled? When should the parties file their respective documents and supporting evidence? And all that taking into account the fact that you have both statutory limits, maybe under the Act or under the substantive law, or you have contractual limits within the arbitration agreement. So in short, the preliminary meeting is supposed to give you that understanding or a framework within which the arbitration process is going to be handled. And once all the issues have been dealt with, then any subsequent processes will be much easier. Now, after the preliminary meeting is concluded, you're supposed to reduce all the agenda items or issues raised during the preliminary meeting into a procedure order number 1. This procedure order number 1 is almost it's the most important of all the procedure orders because it gives an indication of what has been discussed and how the arbitration is going to be handled. Any procedure orders that come subsequent to that are either doing extensions or they are adding matters that are arising as the arbitration is ongoing. So it is important that after the preliminary meeting has happened, then the next step would be to issue a procedure order number 1 that will now formally kickstart the process of arbitration. So hopefully that answers the question. Thank you.
Thank you very much. So we have dived into our preliminary meetings, you've taken us through the mention, you've gone further to introduce us to procedure order number 1. So now I'm a first-time ADR practitioner. Kindly, briefly, Albert, share with me effectively, how can I manage the parties? Started. How do I manage the parties situations? We've seen one of our own has handled quite high-profile conflicts, but I'm also sure all our panelists have. But how can I effectively manage while balancing procedure flexibility and fairness in due process? Because as we all know, one of the key aspects of a good aid is partiality as a tech. Albert, briefly.
Yes, thank you again, Amina. When it comes to management of the parties, this goes back to the discussion that I started with, the issue of preparation. When the appointment comes, the first thing to do is to read the parties, either correspondences, because unlike the traditional litigation, where there are specific things that you file at specific times, with arbitration, it can start in any way. It could be you could receive a letter first, and the parties are saying you have been appointed. Others could give you a copy of a notice of arbitration. Other times you could receive a request of arbitration. So it all depends on which information you're being given. Now, the next step would be reading this information. It could be very limited, but sufficient for you to understand maybe what the nature of the dispute is. And having had that understanding, then the next step during the preliminary meeting is make sure that you are able to address all the concerns of the parties. The concerns start from having a detailed agenda, making sure that all the items, because when these parties come, sometimes it is their first time to be in an arbitral process. Therefore, the reflection they have is that from court. So sometimes they come when they're, being adversarial, they're still fighting against each other. So you have to make sure that you're able to contain these people, the parties before you. Now, how do you contain them? First things, like I mentioned, make sure you have a proper agenda, because once everything is streamlined, then the points of conflict reduce. Secondly, like Engineer Cyrus pointed out, is the issue of stating any conflict or which you might have, conflict of interest, because whereas the parties want you to decide their dispute, at the same time, you're also being put on a pedestal. Who are you? Are you linked to any of the other, whichever side it is? So they're trying to see, are you worth the weight that has been put on you? So you have to make sure that you declare any conflicts that you might have, and where you feel the parties, because there'll be instances where the parties try to reach out to you or to do anything, you make sure that you communicate to them family that since you are now handling the dispute, you are not in position to talk to them, have ex parte communications. So when you handle things objectively, it is much, much easier now to reduce the tempers, because now the process is more objective. They know what to do. They know when to file. They know when the hearing is going to happen, and they know when the decision is going to be rendered. And the fact that you have already declared that you are impartial, they are more comfortable with that process. So when it comes to resources that you might need to help you with, one of the resources that I found very helpful, there are guidelines by the Chartered Institute on dealing with arbitral processes and mediation and the like. But there's also the ancestral notes on organizing arbitral proceedings 2016. I found them very helpful because they take you through the entire process. And the beauty with these is that they are publicly available, in that both you, the first-time arbitrator or ADR practitioner, can access them, as well as the parties themselves, so that you're able to move on smoothly. And then the most critical element in arbitration is party autonomy. Always engage the parties in whatever decision that you want to make. Because like any other process, there are times when you issue directives and the party cannot file in time, and they have reasons for it. Unlike the traditional court system where you have to file a formal application, you have to now tie in the flexibility of arbitration. And when you're tying in that flexibility, you have to make sure that you have consulted both parties and say, look here, your counterparty is seeking an extension. What are your views on this? So that it doesn't feel like it's a unilateral decision made by the arbitrator. Whereas, let's say the Arbitration and Conciliation Act in Uganda, I believe Wambui will also bear witness that the Kenyan Act, well, it says the same, that should there be issues concerning procedure, then the arbitrator is the final person to make a decision on the procedure, whereas you must give the parties the first opportunity to make that. So I believe when you tie in all these things, that's how you're able to balance both dealing with the parties, because this is a human activity. AI is on its way, but it's still a human activity. So you must be able to manage their expectations, deal with any emotions that might arise in the process, because it's still an adversarial process. And then most importantly, making sure party autonomy and procedural flexibility is achieved well at it. So thank you.
Thank you very much, Albert. I must say, as a construction practitioner, I'm a quantity surveyor by profession. when we dive into these discussions, every point, every aspect that you introduce, I feel like, the listeners or those like myself who are not lawyers, would want to understand, would want to really relate, with some of these terms, party autonomy. We have several principles within arbitration that I won't dive into. But to our viewers, to our listeners, this afternoon, please look out for more of similar webinars where we'll be diving into, more detailed discussions for these things. But having introduced us to the aspect of impartiality, and when we were starting, Engineer Titus shared with us key stories to his practice as an adjudicator. Engineer Titus, we have established that impartiality is a cornerstone of any arbitration, any ADR practitioner, be it adjudication, be it arbitration, be it mediation. How can it be practically demonstrated throughout our proceeding? You have disclosed, you've gone through disclosure, you're now, parties have expressed confidence in you to be impartial while executing your duties as a sole, arbitrator or dispute resolver, or I'm on the board. So how can it be practically demonstrated? Just quickly share with us, those of us who are going to have our first time appointments, how can we demonstrate this throughout proceedings beyond mere theory? Thank you.
Okay. Normally the best way is to give examples, because I'm sure people have read the theory or some may have experienced the theory. I mean, I had a case one time where I think it was a first case. I think it was a first case or second case, where there was it was clear that the parties did not know the conduct of procedure for that specific case. It was an adjudication case. So what I did there is I decided that I gave them a small briefing about what adjudication is. And then I told them how we were going to deal with pleadings, whether oral or written. So along the course, number of pleadings here and there, and what happened is one of the parties attempted, actually not, no, I think it was out of ignorance. One of the parties sent me a written pleading, but did not copy in the other party. Now, I believe they were doing this out of ignorance, but what I did is when I responded, I reattached the pleadings to my email and notified the other party that, look, I have received the pleading from this party. It's as per our schedule. I am putting you in copy because the claimant only sent the pleading to me. It's a written pleading. So that's a scenario I can give you. The other one is, this one was an oral pleading, okay? So a claimant had given a written submission. The respondent had given an oral submission. I mean, the claimant had given an oral pleading, and the respondent had given a written pleading. But before the hearing was scheduled, the claimant had not given a written pleading, a response to the respondent. So at the hearing, the party asked, but I have not had a chance to respond. So what I told them is we still have time until the decision is issued for you to plead, but we have a cutoff date when I expect all pleadings to be in, because parties can tend to give pleadings and pleadings upon pleading upon pleading. So you need to control the procedure, like Albert has said, but at the same time, you need to give each and every party a chance to respond to either party's case, considering that the parties might not have the knowledge of how the procedure is run. That's all I have to say for that question.
Thank you very much, for that brief and concise response. Albert introduced us the aspect of party autonomy. You've mentioned the party autonomy, where which is also another principle on its own, which we shall dive into in other discussions, other webinars. But back to you, Wambui, with party autonomy at the forefront of ADR, and some of the few challenges, that Engineer Titus have mentioned that you may have from party representatives and the like, from your experience, give us what are your most critical ethical challenges faced during a first ADR appointment, and what practical guidance would you offer to navigate these, picking from where Engineer Titus has stopped, and also Albert.
Thanks, Amina. I think ethics is a tricky subject, and it will always be the forefront of arbitration. And that's because of the manner in which arbitration is designed and modeled. Now, arbitration is almost a mirror of the litigation sphere, save that it is predominantly led by the parties. Now, the way the arbitration proceedings are conducted, even if you look at the Arbitration Act, it is intentional that there is minimal to no court intervention, because you are to give the arbitrator as much authority as is practically possible, and you are to give the parties as much autonomy as is practically possible. And that is intentional by design to make that proceeding distinct from the litigation proceeding. Now, because of that structure, there are, I'm looking for the appropriate term to use, but there are clever draftsmen and women and clever parties who are aware of the loopholes that exist in the arbitration framework and seek to exploit those loopholes. So one of the major ones that we've seen is the oversight. Ideally, arbitral proceedings from start to finish will not have court intervention except in two areas. One is to preserve the subject matter, and two is where you have a direct issue with the arbitrator. You want them to be taken out and you want them to be replaced. Those are the only two interventions up until the award is rendered. So for all intents and purposes, once the arbitration proceedings start until an award is determined, everything that goes on there is truly at the behest of the arbitrator and the agreements between the parties. Now, delving a bit more into that and just lending credence to the question of ethics, the first thing I ensure to do at all material times, and I know Albert made reference to that, but it's crucial, is to ensure to communicate to the parties at the outset. Because again, like Engineer Titus said, not everybody is as well versed with the arbitral proceedings as you would assume. So it's important to state from the outset that the arbitrator is not in a position to have any correspondence with either of the parties. One, for me, in my personal capacity, I do not allow for telephone conversations in any capacity whatsoever. That's the first thing. But secondly, if we are to have communication, it must be in written form and it must be copied to the other side. There are parties who are going to say they forgot, or it was a mistake, or all manner of other things. But again, because you're not only a neutral party, you have to be seen to be a neutral party. So the two go hand in hand, right? And so even in such a scenario, you have to bring it to the other party's attention. This is what this party has said. When you're responding to them, copy them back in. This is what the party has said. These are my directions. Because again, you have to keep that neutrality to the situation. So that's the first thing, making it abundantly clear at the outset that correspondence cannot be between you and one party. It has to be with both parties at all material times. The second thing is, which I think has been exhausted, but just for purposes of good order, is conflict. And that happens in different forms. Personally, because I am a counsel, and then I also act as arbitrator, there are very many times that perhaps my law firm or my colleagues or perhaps any other capacity, perhaps I'm going up against opposing counsel in a litigation matter, and then they are before me as an arbitrator, it's important to just disclose it at the outset, because again, you need to look as honest and as neutral as possible. But these are the things that are within the control of the arbitrator to do. Let's turn to the things that are outside the ability of the arbitrator to foresee, perhaps. Obviously, you'll be able to control them, but perhaps you wouldn't be able to foresee them. And I'll give you two examples. I had a matter much earlier when I was starting my arbitration journey, and I think we'll get into examples a bit more, but one of my early ones, probably top 3 when I began. And you have to remember, when you start arbitration proceedings, it's because the parties have been unable to agree. There is a dispute, right? And so these parties, in this scenario, it was an ad hoc, which means the parties have asked around, do you know an arbitrator who can deal with this matter? Your name comes up, they write to you directly, you commence. So ad hoc versus institution means you don't have the safeguards of chartered institute or any other institute sort of backing you up and giving you that comfort. You're just sort of on your own. So in this scenario, one was a public entity, one was a private entity, the parties to this dispute. And it was a tender that was done. They alleged they fulfilled it. The other party did not receive payment. They're at loggerheads. So we go through the preliminary matters. We do a timetable for the exchange of pleadings. And Eureka, miraculously, at the point that the statement of claim is filed, but before the defense is filed, they enter into a consent. Now, I don't think that is unique. I don't think that that's a coincidence. I think that that is clever drafting. Those are clever parties. But at the outset, when it's your first, perhaps your first few arbitrations, you're going to take it at face value and think, oh, great, the parties have gotten to a consent. I don't need to do anything further. Well and good. But I think that's when you delve into all it is that you've learned. And it's not only the theory, it's now the practice. Because why would parties come to you to resolve a dispute that they could have gotten into a consent into in the first place? What was even more shocking is that they wanted me to adopt the consent as an order of the tribunal so that they can go to court and have it as an order of the court. Now, again, it goes back to, if there's an easier way to do it, cheaper way to do it, why are you before me? And those are the ethical issues that are not necessarily apparent to you at the outset. Maybe it's you need a few probably exchange of pleadings, exchange of correspondence for you to, sort of question the conduct and the purpose behind some of the actions of the parties. But you have to remember that you can do all things to be upright and correct, but that does not necessarily mean that the parties before you have the same intentions. And so you should always have your wits about you. Don't be too quick to make a decision. Consult, seek advice. In fact, even when they come before you, because 9 out of 10 times they'll give you a lot of pressure to do something within a short window of time. Just say, yes, I'm going to look at the pleadings and I'll get back to the parties in short order. So also it's just to have the mindset that there can be things outside of what it is you have intended for those proceedings that can come up. A second example that I'd like to bring out, and it came up actually probably last year or the year before, quite recently, is that they can also do things at the outset. So there was a matter in which it's an employment dispute, and the employer kept insisting. So the dispute from the employee's perspective was that there are other parties to this arbitration proceeding. Now, for all intents and purposes, the contract there only speaks to 2 parties, but the employee was vehement that there were other parties to these proceedings, and they lend credence to the things that they are trying to advance in the arbitration. And the employer kept saying, no, you cannot allow any other party into these proceedings. You can't allow them to say anything. You can't allow them to file anything. They were very stringent in that way. And to my mind, I thought, the employer has a point, because when you look at the letter of the law, if you're not a party to the arbitration agreement, then you just know you don't have locus to be in these proceedings. That's the truth. But at the end of the day, all of this is being said verbally or through correspondence. There's no actual pleading before you that says, these are the parties. I don't want this person in for this and that reason. And in obviously, as time went on, it then came to light that actually there were multiple people acting as agents on behalf of the employer, but they did not want those people in. But to the extent that they were acting on your authority and doing things on your behalf and in your name, well and good, they cannot be parties, but that's evidence that must be before the arbitral tribunal. So again, you never know how exactly parties are approaching you. You can always have good intentions, but my 2 cents would always be slower to make the decision. You'd rather be slower and be right than be quick and be wrong. And I think when it's your first few ones, the nerves, and, you don't want to come across as incompetent, or, you don't know what it is that you're doing. So you're very quick to make a decision and to come across as authoritative. But I think there is something to be said about listening to both parties, saying, thank you, I'm going to consider that, and then circling back to them in a day or two after you've had time to look at the documents without pressure, had time to consult other people, had time to research the question at hand, and then circle back to it. So just to sum up the question on ethics, I think it's crucial because of the model in which arbitration has been set up. I think you as the arbitrator should do all things to appear neutral as possible, trustworthy, and objective, but also you should always have your wits about you as to what the parties or their counsels may have intended for those proceedings, and ensure that you're able to mitigate them and meet them at those perhaps unique scenarios. That would be my feedback. But again, any clarification, drop it in the comments and I'll clarify. Thank you.
Thank you very much, Wambui. That was quite elaborate. You more or less, made us rush to our next aspect of this discussion. But I think the word you're looking for is cunning. Some party representatives are quite cunning, and especially for first time, you need to be grounded in whatever you're doing. And I think most times you really have to come up as authoritative, because some are quite intimidating. Yes, Albert mentioned that there's young in age and young at heart. But more often than not, when representatives walk in and they look at you and you're young in age, sometimes they may resort to, intimidation and the like. So, like Wambui has said, you don't have to be just a neutral party, but your actions have to speak the same. And at the same time, stay grounded in your decision and don't be quick to judge, to make a decision or move forward in certain aspects. So that brings us to, ladies and gentlemen, there's a lot that we can discuss on proceedings. But for now, we're diving into the conclusion of the proceedings, which is the award, the decision of the adjudicator and the like. So after quickly analyzing the disputes issues, being impartial, excuse me, being impartial, you've gone through, let's say you've jumped the hurdles of court intervention and other aspects. How do we make this decision? How do we finally conclude our first dispute that we are resolving as ADR practitioners? So Albert, over to you. Given that parties turn to ADR seeking a clear and enforceable outcome, what common pitfalls should first-time practitioners avoid when drafting decisions and awards? We want to give credit to the process, and I believe none of us would want to, render an award and then have it challenged at the end of the day. So kindly give our listeners a few pointers. Thank you.
Thank you, Amina. When it comes to the arbitral process, like Wambui has highlighted, you must be on your guard at all times. And you make sure, as we started from the preliminary meeting, the first procedure order, the parties have gone ahead, submitted their respective pleadings, you have had the hearing, the parties have been cross-examined. In there could be aspects where you, as the tribunal or as the arbitrator or as part of the tribunal, you have questions to the parties. You make sure that these questions are put to the parties. So you must be well conversant with the parties' case at all material times. Because as soon as you're done, the parties expect a decision. And when they expect a decision, you must be able to deliver the decision within a limited time, or sometimes you have to make sure that you do not extend the period. One of the things that has been vital in making sure that you come up with a decision that is enforceable has been to maintain a checklist where you look at your award and you're able to look at all the aspects of the award to see that it conforms both to, if it is a domestic award, it conforms to the Arbitration and Conciliation Act. And then secondly, it also conforms to the applicable arbitration rules. Because the rules could be different. It could be any of the institutions, it could be an international institution. So you must make sure that it conforms. Now, the most common things that you need to look at when you're looking at the award, the general items. That is, does the matter before you show the case number and the reference number? Because as arbitrators or as ADR professionals, you have many matters that come to you or where you are appointed. You could find yourself voting one or the others. And that becomes problematic. The second one is indicate whether the decision you are rendering is final, interim, or partial, because this is important in terms of enforcement. Are you going to enforce an interim award? Are you going to enforce a partial award? Depends on the jurisdiction that you're dealing with. Then the overall general structure, paragraph, margin, and table of contents and all that. The second major item is you identifying the parties, their representatives, and the arbitrator, so that no one is in doubt who the arbitrator is and who the parties and the matter before the arbitrator, because there will be instances where there are multiple arbitrations arising between similar parties or one of the parties with others. So it is important for you to be able to identify, but also still goes back to the issue of enforcement. You don't want to have an award that cannot be enforced, or it will be enforced against the wrong party. And I think we had that issue. It arose in the Alcon case, where Alcon International, we had Alcon Kenya and Alcon Uganda, and the arbitral process had been pursued by Alcon Kenya, yet the party that had signed the contract had been Alcon Uganda. So the matter went up to the Supreme Court, and after 15 years or so, it was realized actually the party pursuing the matter had no direct interest. They just shared a name. So you don't want to be in such a scenario where you're dealing with a non-party to the arbitration, because it goes back to party autonomy, the parties agreeing to have their disputes decided by arbitration. So if one of them is not a party to the arbitral agreement, then they have no business being part of the process. And then the addresses. Now, why is an address important? There is a case, I think it is Heat Telecom versus UTL. It's an Australian decision, but arising from Uganda, whereby an enforcement was sought to be made in Australia, and the matter went before the federal court in Australia, and the party was resisting enforcement on account that they were not served or they were not aware of the arbitral processes. And the question turned on whether the address that was put in the agreement was the address that was in the agreement was the effective address for service. The court was quite clear that if there was no indication that the address had been changed at any point in time during the contractual relationship and subsequently during the dispute, then service on that address was sufficient for purposes of enforcement. Was sufficient. Therefore, any process that was made for the arbitral process and any enforcement thereafter was effective. So it was a very, very important decision, and you have to have that in mind. And then the other is the arbitration and choice of law agreement. Like I've mentioned, and both Cyrus and Wambui have highlighted the issue of party agreement. So you cannot handle the entire process of arbitration for you to only realize that there was no written arbitral agreement, because it's the one that establishes your jurisdiction. It's the one that mandates you to determine the process. Because there are also instances, and I think Cyrus would attest, where the clause is hybrid, in the sense that you must start with, let's say, negotiation or mediation, then go to adjudication or a DB process, and then finally you have to come to arbitration. So as you have gone through this matter, you have to be sure that all those preliminary processes have been concluded before the matter is before you. So even when you're writing your word, you must make it clear if they were handled or they failed, so that the parties are quite clear, because it will come up when the party is resisting enforcement. And choice of law, this goes to the issues of seat. You want to be, if there are applications to the court or subsequent enforcement or challenge, you want to be sure that the party's seat is either stated. Whether it's stated, you highlight it. If it is not, then the general law takes precedence. History of the arbitral proceedings. You want to make sure that you make a summary of all the procedural steps that you have made from the beginning of the process up to date, all the procedural orders that you issued. When we mentioned the terms of reference, highlight the terms of reference. And then if there have been instances where assistance of the arbitral institution has been required on a certain matter, then you highlight that as well. Or if there are instances where you have had to make interim decisions on interim measures or any other applications, you indicate the applications and the decision rendered and when you rendered that decision. So then jurisdiction, general jurisdiction, then finally issues to do with costs of the arbitration. It's quite important because as an arbitrator, you must deal with all matters before you. So one of the issues that arises if you have made a decision, you must deal with the issue of costs. And in most cases, what happens is that you have two ways of dealing with it. You either have the parties make submissions, the costs as part of their general submissions, and then you render one award, or in the alternate, you give them an opportunity to discuss the costs and then render separate or additional award on the costs. And then finally, you have to make a dispositive part of the award where you are actually putting down your orders and directions. So with this, that's how an enforceable award would look like. But also to add briefly, I know we're running short of time,
Yes, we are.
is that, yes, have a proper record of proceedings. A record of proceedings, because when it comes to enforcement, the award must be accompanied by two things, especially in Uganda. That one, you have the award itself, and secondly, you have a record of proceedings, which the parties will confirm that is the true the record, the true record of what transpired, and three, a copy of the arbitration award. Now, when it comes to the record of proceedings, the courts, yes, just because this is an important thing, the court has dealt with it, where an award was set aside just because there was no record of proceedings. So just to give the participants the citation so that they can always read the decision of Ken Lloyd Logistics Uganda Limited versus Frach AG, which is miscellaneous cause 78 of 2023. So I think with that, that's when you would say you have a properly enforceable decision. So thank you so much.
Thank you so much, Albert, for that. I must say it was like a crash course on how to write a very, really good decision. But at the same time, you did justice to the question on highlighting how to avoid the pitfalls, how to avoid pitfalls in drafting your decision. With that, I'll quickly invite, well, I must say our time is fast spent, and I request that we keep our submissions brief so that, we can be able to share what we prepared with our listeners and also give them time to ask questions. In case you have any question, kindly drop it in the chat, feel free. We shall address them after. And also, Albert, if you can drop the authority you have cited within the chat for anyone who would love to refer to it. With that, Engineer Titus, kindly, given that you've gotten your first appointment, you wanted to share with us your first appointment, but within that, kindly share with us how kindly share with us how the challenges that you might have faced in that first appointment, and how can our fellow practitioners handle similar challenges or even other challenges briefly in 3 minutes. Thank you.
Okay, thank you. There's a gentleman whom I'll refer to as James. I went to school with James. We left university together. We were in the same faculty, but he did a different course. And we ended up working in the same organization for a long time. James became the president of our local institution of professional engineers in Uganda, which quite often receives construction cases for arbitration and adjudication, rarely mediation. 4 years ago, around this time, I approached James and told him, look, I have gotten on this train and I need you to assist me get an appointment. So what happened is he listened to me, understood what I was doing, and I got my first appointment on the 24th of June, 2022. It was an adjudication case. The lessons I learned from there are that people will give appointments to those that they know. And they can know you either directly or indirectly. There is no two ways about it. Second thing I have experienced is that these qualifications that we are pursuing, FCR, Master of Science in Construction Law and Dispute Resolution, non-ADR practitioners do not appreciate the weight that documentation carries or that those qualifications carry. So it is difficult for you to convince anybody that you're actually competent. And what tends to happen is that you're overlooked for an opportunity, yet you are the best suited candidate for it. So the advice I can give to the listeners is that try to make yourself visible in whatever way you can, so that you are noticed, but also favor comes to those who return it. If you don't return favor, you don't expect to get an opportunity. I do not know how Wambui or Alex got their first appointments, but it really circles around someone giving you a chance. But also when you get a chance, do a good job, because the person who has recommended you is relying on you to do a good job. So if you disappoint them, it's really a problem. So my first opportunity was solely out of the favor of an individual that I knew. And I got other subsequent cases after that. But the subsequent cases I got were because of how I had performed in the initial case. It's very difficult to get the first opportunity. Whether it's an arbitration, whether it's adjudication, whether it's on a dispute board, it is extremely difficult. It takes people years and years and years to get just the first opportunity. So, but I want to encourage people to hang in there, but understand that favor also follows those that return it. Thank you very much, Amina.
Thank you very much, Engineer Titus. You reminded me about my first appointment, or if I may say, attempted appointment, where I was approached, and unlike other people, I turned it down out of, I think, for me at that point, I felt like I'm not ready. But up until today, you know, I that's one of the things I regret the most. But there are always other opportunities. And whereas we invest in these accreditations, it's very true that other practitioners who are not vested in ADR will not really appreciate them. But we keep going on. That will take me to Wambui. Within this question, kindly just share with us your first, one lesson that you learned in your first appointment and how it has shaped your practice to today.
Thanks, Amina. I've learned so many things from my first, even the appointments I'm getting now, I'm still learning. And I think that's one of the first things. I think if you walk into proceedings believing that there is a point in time where you know everything, that's a falsehood. I think every case is unique, every circumstance is unique, every party is unique, and therefore you should always be in a position to be malleable and flexible to adjust to whatever scenario circumstances is presented before you. Obviously, we'll always have a good foundation, assuming that you've done your courses, you know the law. That goes without saying. That's the same as everybody else. But I think the thing that sets you aside as an arbitrator, and a good arbitrator, is how adjustable you are to circumstances. So I think that's the first thing I learned and I continue to learn. Know your craft, know it well, so that there is no question, there is no doubt, there is no concern as to whether you are well versed with not only the procedure or the law, but the matters before you. So be as well versed with the information as you possibly can be. And that also stems from preparation. I can't emphasize enough how important preparation is. In the same way, many of you perhaps are already lawyers. The same way you prep for a hearing before you go into it is the same way as an arbitrator. It's incumbent upon you to review the file, know the facts, know the evidence, know the witnesses, such that even when the parties are before you, you know what you're looking out for. You know, people come and bombard you or just dump information in front of you, and it's for you to decipher that and know where the cracks of the matter are and where to place emphasis. So I would say definitely know your craft, but also do the hard work, do the behind the scenes, and make sure that you are getting organized and knowing your brief very well. I think something else is have confidence. Don't second guess yourself. The fact that you've come this far and already people are looking at you and wanting to appoint you, it's because you know what you're doing. Obviously, there are nerves, obviously there's second guessing, but at the end of the day, my motto to each and every person I'm constantly mentoring is do it and do it scared. Do it scared, but be in the ring, because when you're out of the ring, then you're telling yourself, okay, next time I'll be ready. You'll never actually be ready until you just do it. So get in there, do it, give it your best shot. And the best thing about it is you can always consult, which is why I say be slow to make decisions. Hear the parties, get all of the information, tell them you come back to them, then go and read, go and consult, go and research, such that by the time you're coming back to the parties, you're on solid footing and you're sure about what it is you're doing. 9 out of 10 times, you already have a good idea, but you just need to confirm that what it is that you're thinking is correct, and that's perfectly fine. Something
Thank
else that
you very much.
one more thing,
Okay.
just for the young people, and to be very quick. I know everybody emphasizes money, and I know money is important, but I think that when you're having your first few arbitrations, don't focus so much on the money. Focus more on the experience, the exposure, building your brand and putting yourself out there. The money will come. That's natural. As and when you perform properly, the money will come. But if you place money as your point of emphasis, I think you're cutting yourself short and taking yourself out of the game. So I just wanted to point that out. Other than that, you're capable, believe in yourself, know your craft, be organized, be confident. That's my parting shot. Thank you.
Thank you very much. Wow. As we're nearing the conclusion of our discussion this afternoon, please feel free to drop questions in the chat. We'll discuss. We're about to dive into the Q&A. But as we conclude, I just want each of the panelists give us one challenge that really has stood out for you when you started, and how you maneuvered that challenge. Because as you've said, as a young practitioner, or even if you're young at heart, but you're young in the practice, you're going to have one or two challenges starting. I know we have mentioned some of them as we go, as we were discussing. The aspect of being confident, being grounded, being neutral, but just give us in 1 minute, give us an example and how you maneuvered the challenge. Thank you. We shall start with, let's start with Albert.
I think the challenge is making sure that the parties comply to the directive, because these parties have come before you, they're seeking justice, they want their matter to be resolved, but at the same time, for one reason or the other, I think the initial challenge was complying to the directives, because there was a feeling maybe the process is not as rigorous as the court want, but making sure that I put them in a place where they understood that failure to comply had repercussions. One of them is well spelled out in section 25 of the Arbitration and Conciliation Act, that should it be the claimant, then I could dismiss their claim, and then should it be the respondent, then I could proceed in their absence. So, and the courts have clearly made it that if a party refuses to submit themselves before the process or find ways of trying to delay it, then the arbitrator is within their right to proceed as they deem fit. So that was quite clear, and then making sure that any subsequent proceedings, it was quite evident. And it ties in with everything that has been mentioned Because if the parties understand this from the preliminary meeting, they have been able to see it in the procedure order. They have also seen it in the terms of reference. So the likelihood of such behavior recurring would be minimal. So thank you.
Thank you very much. Over to you, Titus. Please keep the questions coming. I can see Wambui has responded to some, but we can still respond.
Well, for me, the challenge was on my side, not so much on the party's side. I had very good command of the subject matter because I predominantly work on construction projects, resolving disputes in that arena. The challenge that I had was, I think I was very, very nervous for the first assignment, not the subsequent ones, but the first one. And the cure to that was to listen a lot more than I spoke. And when I decided to do that, I got comfortable and began to ask relevant questions. Because I thought that, I remember in the first case, I actually thought that I felt my tongue getting tied. And I just said, okay, fine, you know what? Please claim and submit, respond and submit. So I let them run, because the thing about being nervous is that if counsel on the other side gets even a hint that you are nervous, you have given them a license to destabilize you.
That's true, yeah.
Yeah, but I found a way to manage it, and it went well. Also, of course, the case where parties are ignorant of the process, just making them comfortable. Have tea, have nuts. If you want bananas, have bananas here. Or if you, the toilets are that side, places of convenience are that side, and so forth. Make them comfortable so that there is no violence in the proceedings. Okay, that basically was the challenge for me, but I eventually outgrew all those challenges. A very unique one is that at some point I thought I would write too much in my decision in an attempt to be clear. But since the matters were pretty straightforward, I was able to write just enough. Albert there will tell you about word count and the challenges he's having with it at King's College, but that is it. Thank you, Amina.
Thank you very much, Titus. You've reminded me of my first arbitration that I attended as a mentee. And, you know, before when we were waiting for the arbitrator, I mean, the counsels, the arbitrator, everybody was, you know, they were free. There was no tension in the room. There was no, but once, you know, the proceedings started, then the guns came out, and then the proceedings stopped, and then you see the friendliness in the room. So it really, I think at that point, I went as the most serious, but then I also learned how to relax. But also the aspect of listening, I think ADR practice has really, really helped me sharpen my listening skills. And that's something I picked from one of my core mentors, listening and listening and listening. Because parties have come for you to listen to them, not for you to, you know, impose here and there. So I must say I relate with your challenges. So we'll have Wambui just give us one challenge, just one, and then we can dive into the questions.
Okay, I'm going to give you a more controversial one. Not that I intend to be controversial, it's just that that's the terrain that we are in. And specifically, I want to talk about women in arbitration. I think that you do not have the latitude to not know your craft, because litigants walking into the room are depending on you not knowing your craft, or are walking in underestimating that you know your craft. So perhaps parties will come and ask you for a discount, whereas they would not ask your male counterparts for a discount because they feel comfortable enough to ask you for that. They will ask you for latitudes in procedure that they perhaps would not ask your male counterparts. They will question your decisions, your directions, your orders in ways in which they will not question your male counterparts. So one of the challenges I would say is being not only a young arbitrator, but being a young female African arbitrator. It is a triple threat. And I think whereas the market attempts to dwindle our light, all the more reason we should shine brighter. So be confident, know your craft. The fact that they think that you don't, make sure that you do. Be assertive, be confident, and take up space, because you have every right to be there as much as everybody else. So that's the challenge, I would say. But I think it's a welcomed challenge. And I think each and every one of us, female, young, African arbitrators, should take it on and take it in our strides, because we are very capable.
You know, from where I am, I'm, putting up flowers for you. Well, you've more or less you brought up the aspect of women in arbitration. Not to be biased with our male panelists, but that's the main reason why we saw it prudent to have a balanced panel, to have to inspire the women. And I'm very, very delighted that you've actually brought up the point and you hit the nail. But I also must say there is space for us to spill. It's just I think many women suffer from imposter syndrome. Whereas we have the male, sometimes, yes, they will put us down, but we also have imposter syndrome. And I think that's something we need to address. And to the ladies listening in, I know we've just completed the Ladies' Month, but please take up the space. Please break that glass ceiling. It's work in progress. I am also work in progress, but thank you for bringing that out. With that, we have had some questions on the chat. I believe Wambui has attempted to respond to some of them. In addition to her response, I don't know if Titus or Albert, you have any addition to that. But I also love to appreciate a young arbitrator listening in from South Africa or from all over Africa. Thank you for joining us. Please keep looking out for our activities and join us when you can. Albert or Titus, do you have any addition to the questions that we have? I didn't want to read them out again, but if anybody else has another question, yes, please.
I think let Albert or Migai take on the questions, because I think they are all in the arbitration space.
I think Wambui has responded ably to both questions. The most important thing is if it is looking at the Chartered Institute, then becoming part of the Chartered Institute gives you an opportunity to be listed on the roll of neutrals. And there are several branches across the world. So you could always choose which one you want to be part of, but the Ugandan chapter equally welcomes you. So, and whenever there are appointments available, then you can be in charge. Maybe Bridget, who should be part of this call, can always reach out to you, or you can reach out to her, and she ably guides you on how to be part of the chapter for that. And in respect to the second question, the choice of selection would depend, like Wambui has put it, the disputes, how they arise, because when it comes to commercial or construction disputes, in my case, it was the class that I was representing that led me personally to choose construction, because I had been involved in the negotiation of the construction contract, had been part of the initial disputes that came up. So eventually, when the arbitrations came up, it was a natural process. So it could also be part of the work you do, but the most common is commercial, because it usually deals with a wide range of commercial disputes. It could be a banking dispute, it could be an insurance dispute that the parties have decided to take to arbitration. So the choice, sometimes you may not have so much leverage, because when it comes to, let's say, investment, you could be trained in investment, but then investment you are dealing for the state. And Wambui has been part of an investment dispute, so she would ably tell you how that comes into place, but there are not as many as the commercial or construction disputes. So you could start out as a general arbitration practitioner, and then you look at the nature of your practice. You could even not be a lawyer. You need not be a lawyer. You could be from the built environment like Amina and Cyrus, and then you're able to build from there. And then how would you cooperative parties to frustrate the process? Like I mentioned, when it comes to the parties, you always give them the first opportunity, you consult them, you have a discussion with them, but you also indicate to them that the law is available to you to take any further decisions. Like I mentioned, under the Ugandan Act, we have a provision that allows the arbitrator to proceed with the matter as they deem fit. So should it be the claimant, like I said, you could dismiss the matter. Maybe just to add, like, for instance, they have added under the English Arbitration Act, they have added summary procedure. So you could also deal with the matter summarily, or you could actually proceed what we call in litigation ex parte, or you could proceed in the absence of the respondent should they not be compliant or cooperative in the process. So there are many things that, there are many avenues available to the decision maker to be able to handle the process without necessarily stalling the process. And when it comes to adjudication or the DB process, if a party refuses to appoint a DB member or wants to frustrate the process, then, for instance, when you look at the FIDIC 2017, the party is free to sidestep the DB and go straight to arbitration. So there are many avenues of making sure that, you know, the process is not stalled. So thank you.
Thank you very much, Albert, for responding to that. But just quickly, I just want to, Engineer Titus, what made you choose the line of adjudication? Because
That's an excellent question, and no one has ever asked me that question except yourself.
I'm glad.
I did not choose the line of adjudication. It chose me.
Okay.
I'm a civil engineer. I've spent the last 21 years in built environment. Okay. The thing about, so if you look at the spectrum of dispute resolution, you have mediation, adjudication, and arbitration at the top end of that spectrum. Okay. Now, for me, one, I'm not an adversarial person. But also the thing about arbitrations is that it only seeks to resolve a matter when parties are in dispute. The beauty about adjudication is that you have a vessel which is known as a dispute board process, okay? And what that does is that because I'm engaged on projects as a dispute board, I also get to remain intimate with built infrastructure, because I see people building, I see them complaining about issues, some with merit, some without merit, okay? And we issue informal advice, we give written decisions throughout the life of the project. In that way, I stay in touch with the project, but also get to practice the craft of issuing decisions or informal advice. You don't get that opportunity when you're doing arbitration. However, I can do arbitration because I was trained to do it as well. I can do mediation, I was trained to do it as well. Even expert determination, I can do it. But I did not choose adjudication, it chose me.
Thank you very much for that response. Why I thought it prudent, it's because, the question regarding what choice of ADR to take, and you've highlighted that aspect of comfort, which also Wambui talked about, sampling the different cases, the different methods, and then you find your line of comfort. Because as we know, ADR is a secondary practice to our primary practice. So if you're really not finding your line of comfort, you're going to find the process quite frustrating. Within our discussion, we have shared so many challenges, but I think any of the panelists can choose to answer this one. The question is, okay, personally, I've been privileged to be part of a number of arbitration proceedings, and they are largely characterized by, can I say, court issues? Not court issues, court characteristics. Let me elaborate. The thing is, lawyers, whereas they tend to be the most in ADR practice because it's I think it complements their practice already. They bring court proceedings, court practices within ADR. And in my opinion, it abuses the advantages or the goodness of ADR, where we are here to actually find an amicable settlement. And if we're able to get a consent award, well and good. But lawyers quite often bring court processes, or they incorporate court processes within an ADR practice. As a practitioner, or during your practice, how have you tried to mitigate such cases or such scenarios? Because honestly, it's I've seen them derail some processes. Yes.
Amina, I think that your question is quite loaded, and to give justice to it,
okay,
we may have to hear from each panelist. I can tell you that there is a lot of sometimes I'm trying to pick a word to use, but sometimes there's a lot of indiscipline in the practice, and it could be across the whole spectrum, where people actually do not know what they are doing. But also you find that there could be a matter that is going on, and it's an arbitration. The arbitrator is a lawyer. The party representatives are all lawyers, okay? What happens in that case is that they all default to how they were trained as lawyers and not how they were trained as ADR specialists, okay? I think that the practice needs balance, okay? And also it helps when the parties are also reasonably knowledgeable about how these practices are conducted, or the procedure of these practices. Because if you are a party and you've come with counsel and counsel is going out of hand, you have all the rights to tell counsel, we have come here to solve a problem and not to litigate the problem, okay? So kindly, let's solve the problem and not litigate the problem, okay? So that is my feedback on that. I would like to hear what Albert and Wambui have to say, but it's a very, very loaded question.
So when it comes to that, of course, in most cases, you're well aware that even in litigation, it's always a fight. It could be an application, it could be anything before the judge or whoever it is. And the parties are trying as much as possible to make sure that they're reflecting. So to me, it has always been a question of preparing the parties. And that's why the preliminary meeting to me is very, very important, because I use this as an opportunity to inform them of the nature of the proceedings and allow them to share what exactly the issues are. And in any case, there have been instances where the parties try to bring applications which are intended either to frustrate or prolong the matter. I deal with them either summarily or I make quick decisions on the matters. We may not be able to completely remove this, but once the parties are able to understand the nature of the process, because one, they don't want to show that maybe this is my first time in this arbitral process, and what I'm used to, like Sarah has pointed out, is the court process. So they try as much as possible to configure that into the arbitral proceedings. So as much as possible, give them information, indicate to them that whereas there are some aspects that are similar to the court process, but then here we do not go into unnecessary applications and whatnot. So for me, it has not been much of a problem because I understand the landscape, but also the fact that I provide as much information as possible to the parties.
Okay, thank you very much. I think our time is...
Maybe just to add one more thing. When it comes to party representatives, what Cyrus hinted on, I've had a case where it was a construction dispute. Because of the flexibility of arbitration, I acted together with the QS in the matter as a party representative. So I'm a lawyer, then the QS. So we did the work together. So that shows you the kind of process, and we're able to smoothly handle the matter, and we got an award in our favor. So it is possible to integrate other disciplines into the process, and it's also possible to teach the learned colleagues the flexibility when it comes to arbitration.
Thank you very much. I must say that's a very good way to conclude our discussion this afternoon. As Albert has said, lawyers can have co-represent with practitioners or experts from other fields. And when you mentioned the quantity surveyor, I look forward to being a co-representative on a future dispute, inshallah. But with that, I want to appreciate our listeners. Thank you for staying with us this afternoon. I'm sure the next calls are going to be about Oliwa. I'm sure we're going to represent, but before we log out, allow me to just summarize our discussion this afternoon. Well, we have looked at highlights on how to secure your first appointment, and most importantly, how to prepare for it. It is important that as we conclude, it is evident that a first ADR appointment is not simply a test of knowledge, but of judgment, integrity, and professionalism. The journey into the practice does not begin at the point of appointment, it begins with preparation. And as wisely said, failing to prepare is preparing to fail. But for those of us listening in, I'm certain that we are definitely preparing for our first appointment. And those of us that have already gotten our first appointment, I wish you all the best as you conclude it. And I hope that it opens up doors for you. Those in diaspora or different geographical areas, please, the contacts that have been shared for the Uganda CEB, any comments, if you want to be enlisted as a panel, if you want to have work in Uganda, please feel free to reach out to Bridget. There are trainings that are ongoing. If you still have some modules to go, the Chartered Institute of Arbitrators is doing trainings, and there are 2 that are happening this month. I know even CEB Kenya has trainings that are going on. I personally started my practice from Kenya, so I know that they also do a really good job, and they're our sister, they are our, can I say, our sisters and brothers anyway. But we were more or less started by the Chartered Institute of Arbitrators Kenya. It helped start the Uganda chapter. So we work closely with them. With that, kindly reach out in case you have any questions, any young members that would want to, join CIAB. If you have any questions, reach out to Bridget, reach out to myself, or any young members, or even Albert. All these people are very accessible. And please look out for our upcoming activities. And we look forward to hosting you and building more of the ADR community. Thank you very much. Taking you through this moderation was Amina Nasazi. Sorry, I forgot to introduce myself. I think the nerves or the excitement, but with you this afternoon was Amina Nasazi. I'm a quantity surveyor by profession. I'm a construction manager, and I'm a member of the Chartered Institute of Arbitrators, currently serving as a vice chairperson for the Young Members Committee. I look forward to interacting with all of you on other platforms. Have a lovely Easter weekend. Thank you very much.